Hello and welcome again. We've covered a lot of ground over this series of talks, but the central theme has always remained the 1215 Magna Carta, with special emphasis on Article 61. I've always tried to bring the attention of the viewer back to this prime topic, no matter to what other subjects we've diverged. The reason for that is that Article 61 contains the kernel of the ultimate truth according to natural law as to how humans are best advised to deal with one another. Article 61 contains 7 main provisions or parts. First, there's the promise made by the monarch, speaking in the plural, that is, using the royal we or us, indicating that this is a promise or commitment made by the office bearer henceforth and not just King John, that this obligation is to exist forever or in perpetuity in the form of a security. Secondly, there is the explanation of the process by which the promise may be invoked and enforced, which details how a committee or jury of 25 barons or peers of the monarch may present a grievance to the monarch or their chief justice if they are absent, and specifies the period of time given by which such grievances must be redressed. It's important to note that the offences don't have to be committed by the monarch, but by any of their officials or servants. The monarch is thus accountable for the actions of those they have appointed to assist them in their administration of the realm. Thirdly, there's the instruction to the barons as to how to exact redress from the monarch, including the actions they may and may not take to secure such redress. Fourth, there's the permission, accompanied with an actual command, for everyone in the realm to join with the barons in seeking redress or restoring justice. Fifth, there's a provision for how the Barons' Committee is to function if any of their number dies or is otherwise unable to participate in their joint action, and how to resolve any differences amongst the Barons as to verdicts, etc. Sixth, the Barons are charged that they shall faithfully obey the articles of the Charter and cause them to be obeyed by everyone to the best of their ability. And seventh, and finally, there's the promise that neither the monarch nor their servants or any third party shall seek to procure anything which attempts to revoke or diminish any of the concessions or liberties protected under the Charter, with the categorical statement that any such procurements shall be null and void. Despite claims to the contrary that Magna Carta 1215 was annulled by the Pope, Innocent III, or was rewritten by succeeding monarchs, or replaced by a statute law in 1297, none of these things are true. Magna Carta is not a statute, so it cannot be repealed. Parliament did not exist at the time of Magna Carta's inception, thus it remains a treaty or agreement between the participants, which were the monarch and his peers, their officials or servants, and every other person in the realm in the event of the security clause being invoked. A third party, such as an assembled parliament, is specifically excluded from taking any action which might lessen or remove any of the liberties protected under the Charter. There are a number of tremendously important principles underlined in Magna Carta 1215. They weren't created by the Charter, but represented the first time that these principles had ever found expression in written form in any document bearing the weight of constitutional law. These are the principles which ensure the prevention of harm between individuals and which also define all members of a community, from the highest ranking to the lowest, as possessing the same intrinsic value as individuals and validity before the law without exception. This principle of equality before the law means unequivocally that if we take any two individuals selected at random from the population, that neither of them has any innate authority or power over the other. That being the case, how is law and order to be sustained should one of them choose to infringe the rights of the other, or indeed, if not by intent, but by accident or neglect, causes harm to that one? It had been agreed among communities for many centuries in Europe and in England that if one was accused of such offences, the matter should be determined by a trial before a jury of one's peers. These would hear the claims and defences of both parties and would, with the help of a convener who was well versed in the law, if such were required, decide what was relevant evidence and decide upon the facts of the case, as well as the sentence, if any. They would also decide upon the justice or otherwise of the law or legislation which had flagged the case, and could dismiss the matter or effectively annul the legislation if they deemed it to be unjust, meaning in breach of an individual's natural rights. This was the custom of the land, and had been a part of the monarch's coronation oath since the time of King Edward II. King John had sworn to govern according to the customs of the people, which is why in Article 39 of Magna Carta 1215 there is the promise mentioned in the last video and others of this series that no one shall have any official action taken against them unless they had first been tried by a jury of their peers. All of these principles were upheld by Magna Carta, which granted no rights at all, but merely upheld those which everyone at that time knew already existed. But that is not the case now, is it? How many people, if asked at random what their rights were, could give a correct answer? Not 1 in 1,000. Rather, the questioner would be regaled with a litany of rights which had been granted by various governments under various statutes, many of which would either be self-contradictory or in contravention of the natural rights protected by Magna Carta. The answer is that a right is any action one can take which doesn't cause harm or loss to another. All such actions are right actions, and the converse is true. All or any actions which do cause harm or loss to another are wrong actions, and may carry the risk of lawful penalty, subject to a trial by jury. It's a very simple concept, isn't it? Anyone can understand it without any special training, which is why the age of accountability in law used to be 8 years of age. It certainly was when I was a boy. With the gradual accretion of entire libraries of legislation, which even trained lawyers, judges, and other officials cannot contain within memory, that age is slowly increasing as the distinction between what is deemed right or wrong by legislators becomes ever more convoluted. It's no surprise when one looks into it to realize that this confusion is a deliberate act designed to convince people of their inability to comprehend law, their incompetence at either administering or defending themselves from it, and their willingness to accept the rulings of others over their own consciences and convictions. Man-made laws, or as we properly term them, legislation, are designed specifically to blind people to those simple, elegant principles of natural law that all but the mentally deficient can understand. Even the most ardently committed psychopath, bent as they are upon acquiring personal advantage without regard or conscience to whether they are harming others, still can comprehend intellectually that such actions are not acceptable to the community in general and will bring retribution if discovered. Why else would they try to evade detection were it not so? This state being that of a United States presidential election, it was in equal parts both amusing and depressing to hear the comments being made by the numerous reporters in the media about the unfolding results. To hear media presenters repeatedly misusing words like democracy, rule, and rights, ascribing to them entirely erroneous meanings, and seeing that backed up by masses of individuals entering states of either despair or jubilation at the prospect of having their lives controlled in very great measure by people with no innate right to do so, thus placing themselves in voluntary servitude to egomaniacal sociopaths, can hardly inspire hope for the evolution of a just society. It is a grossly immoral debasement of an individual's self-worth to willingly subscribe to such deceptive chicanery. Of all species of life on Earth, mankind remains the only one to scarcely even try in the aggregate to live as its nature prescribes. All other forms of either flora or fauna attempt to live according to their natures as these have come to be expressed in nature. All make use of whatever advantages nature has provided in their endless struggle for survival and fulfillment, but not humankind. We have been gifted with reason as well as sentience, and have the capacity to determine not only how to deal with and to some extent control our environmental conditions, but also to work out how best to live in harmony with each other, and thus make great leaps and strides in our endeavours by means of cooperation and respect for each other's rights and liberties. But so few do. Untold multitudes bow and scrape before bullies and criminals, hoping to be like the victims in Winston Churchill's famous aphorism about appeasers and crocodiles, eaten last. People strive mightily in their physical and mental endeavours to build economic safety and security for their families, yet never stop to consider how very much further as a society we could progress if only we would stop appeasing the traitors and criminals who, like leeches, suck the lifeblood from all and sundry. The means to put a stop to all this is there, staring us in the face, in Magna Carta 1215, Articles 39, 40 and 61. All we have to do is to stand up in numbers and present those facts to those who seek to oppress us and demand a return to a proper trial by jury system. And the whole house of obscurantist and confusing legislation would come tumbling down, just like the pack of cards masquerading as a court of law in Alice in Wonderland. There is no need to learn this loophole or that obscure false common law statute to try to wheedle a personal victory from some aspect of the legal system, by which such actions we only perpetuate the evil. We only need to cut to the chase and point out with Magna Carta that the entire edifice has no lawful foundation for us to succeed. Of all the species that have existed on Earth, it's calculated that 99% are now extinct. The main reason a species goes extinct is because conditions in its environment change and they fail to adapt adequately to the new challenges. As Homo sapiens, we have been granted by nature, or providence, however you want to call it, the gift of intelligence, the ability to understand to some extent our environment and how to rise unimaginably far above our basest, humblest beginnings. We are now facing a change in our conditions, a far more evil and sophisticated campaign to remove permanently the freedoms which we were born with into this world. Unless we learn how to deal with this using our reason and our courage, are we destined to join the other 99% of species which also couldn't cut the mustard in a changing world? Intelligence and reasoning ability aren't enough to ward off permanent enslavement. Eloquently worded documents won't do it either. It also requires morality and the guts to back it up. If we won't confront facts and accept basic principles, we're history. Thank you for watching.